Welcome and thank you for joining Seyfarth's webinar, NLRB and Restrictive Covenants, Trends in Employment Confidentiality. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A section located on the right side of your WebEx window. We will do our best to get to everyone's questions. Any unanswered questions will be followed up by email after the webinar. For those interested in CLE Credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE Credit. Copies of the webinar recording and presentation materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Alex Meyer. Alex, you may begin.
Great. Thank you so much, Sadie, and thanks to everyone for joining us today. My name is Alex Meyer. I'm a partner in the Atlanta office of Seyfarth John, its Labor and Employment Group, and my specialty is trade secret and restrictive covenant litigation. Before we get started and before my colleagues introduce themselves, let me just read a quick disclaimer, I think. Right, Sadie? Do you want to go back to that, or do we need to read that? Okay, so again, as part of our webinar presentation, it's been prepared by us for informational purposes only. The material discussed during the webinar should not be construed as legal advice or legal opinion on any specific facts or circumstances. This is, a trend presentation versus a specific discussion of state law, and please reach out to any of the folks who are running this call or the relationship partner you have at Seyfarth regarding the specific facts and circumstances you might have. So with that, I'll turn it over to my colleagues, Carrie and Sewell, to introduce themselves.
Sure. Good afternoon. My name is Sewell. I'm a labor employment partner in the Atlanta office. I'm happy to be here. Thank you.
Yes, thanks everyone for joining us. My name is Carrie Burke. I practice in traditional labor law and employment litigation, and I'm out of the Atlanta office as well.
Perfect. Okay, so our agenda today is going to start out by talking about state and federal activity and confidentiality agreements and restrictions. It's been a very active area, and then Sewell and Carrie are going to cover NLRB trends and severance agreements. And then we'll discuss some strategies for risk and compliance and hopefully leave some time for questions. Next slide, please. So starting off with what we've been seeing at the state and federal level, excluding the NLRB. Next slide. Non-competes have always been a bit of a problem child and the real target of political ire. Every campaign season, you would see particularly the Democratic candidate come out and take an antagonistic posture against non-competes. Here's a quote from Biden's plan for strengthening worker organizing, collective bargaining, and unions. Quote, Biden will work with Congress to eliminate all non-compete agreements, except for the very few that are absolutely necessary to protect a narrowly defined category of trade secrets, and outright ban all no-poaching agreements. Now, notice what's not in that quote. Confidentiality restrictions. People understand that we're a knowledge-based economy, right? Our IP, a company's IP, is often its most valuable asset and the crown jewel in its portfolio. So there has to be some kind of protection for companies so they don't spend all this time developing IP, and then just have it walk out the door with their employees. For that reason, confidentiality obligations were historically subject to a less rigorous review than non-competes. A non-compete had, depending on state law, a pantheon of considerations necessary to draft an enforceable restriction: geographic territory, subject matter, protectable business interests. On the other hand, a confidentiality restriction, for the most part, really just needed, first, a category of protectable information that the employee would receive, and then a proper definition of confidentiality that excluded public information. All but 2 states didn't even require a time limit for a confidentiality provision to be enforceable. So the approach to drafting these provisions was pretty laissez-faire. Just don't draft a confidentiality restriction that's so broad in its terms that it amounts to a non-compete, and you could be fairly certain that a court would enforce that restriction in some form. Can you go to the next slide, please? However, over the last decade or so, the concerns about restrictive covenants generally have become kind of a hotbed of legislative activity. There have been a number of efforts to ban or severely limit non-competes. Some of those have been successful. And then legislative activity has been expanded from non-competes, which was kind of the historical focus of concerns about overbreadth, into confidentiality restrictions. Recent state activity impacting confidentiality provisions really stems from two primary concerns about sources of potential abuses. So the first would be the corporate suppression of disclosing potential misconduct. Think about misleading the government, misleading shareholders, misleading consumers, things related to the actual business activity of the organization. The second was interpersonal, the mistreatment of employees. So starting with corporate misconduct, going back to Sarbanes-Oxley, there's been a focus on internal employees revealing misconduct by their employer. Employees are often best positioned because they have access to non-public information, and there was legislative concern that companies would use a non-disclosure or confidentiality provision to prevent an employee from disclosing wrongdoing. Historically, there's been a judicially created public policy exception to non-disclosure enforcement in most states for reporting alleged misconduct to the government, as well as disclosing information to the government as part of some kind of administrative proceeding. That has since been expanded into certain statutes and administrative agency proceedings. For example, a number of courts have held that under the False Claims Act, an individual may disclose confidential information or trade secrets to the government as part of a report of alleged misconduct. The EEOC likewise took the position that charging parties could provide confidential information during the administrative process related to their claims. Can you go to the next slide, please? In 2016, Congress expanded some of those common law protections into the Defend Trade Secrets Act. I'll read a quote from Senator Chuck Grassley here. Quote, "Too often, individuals who come forward to report wrongdoing in the workplace are punished for simply telling the truth. This amendment ensures that these whistleblowers won't be slapped with allegations of trade secret theft when responsibly exposing misconduct. It's another way we can prevent retaliation and even encourage people to speak out when they witness violations of the law." So the Defend Trade Secrets Act, which is approximately 7 years old at this point, contains a whistleblower immunity provision that provides immunity for disclosures in confidence to an attorney or to the government regarding potential unlawful activity. The second basis for kind of the erosion of a pretty expansive view of confidentiality protections is in terms of interpersonal misconduct at a company. In the wake of the Me Too movement, the American public saw that in certain circumstances, confidentiality provisions could potentially be used to enable serial violations of EEO laws or enable sexual harassment. And in response, a number of states initially passed restrictions on confidentiality provisions in settlement agreements. This is going to be state specific, and I don't want to get into the exact details for every state that's engaged in some kind of statutory enactment. So let me just kind of start with a high level takeaway for what you're going to be evaluating when you're looking at whether a confidentiality agreement represents or presents a risk. Number one, could the agreement be read to prevent disclosures of unlawful activity to the government? And then second, could the agreement be read to prevent the disclosure of unlawful activity of any kind in the workplace? If the answer to either of those is yes, you want to look deeper at the particular state's law and see if there are any enforceability concerns under whatever state law you've chosen to apply to that agreement. Can you go to the next slide, please? So here I've got some example language for what we have in terms of what states require. California is one. So in California, there is specific language that must be included in a confidentiality provision in order for it to be enforceable. It says, quote, "Nothing in this agreement prevents you from discussing or disclosing information about unlawful acts in the workplace, such as harassment or discrimination, or any other conduct that you have reason to believe is unlawful." Other states, like New Jersey, haven't required specific language, but instead prohibit a provision that has the, quote, "purpose or effect of concealing the details related to a claim of discrimination, retaliation, or harassment." Now, those are far from the only states that have actually implemented some of those provisions. Other examples would include Illinois, Washington, New York, Oregon, Vermont, and California. But this has really started to change the calculus because a lot of these restrictions aren't toothless. Historically, the only downside to having an overbroad confidentiality agreement was that you couldn't enforce it under the circumstances you were trying to. It was all upside and no downside. However, an increasing number of states have passed affirmative causes of action for overbroad agreements, which allow the employee to claim either statutory penalties, equitable relief, fee shifting, or some combination, or all three of them. So not only could you potentially not be able to enforce the agreement, but you could potentially be on the hook for the other side's attorney's fees. Finally, Congress has revisited this in the Speak Out Act, which was passed at the end of 2022, which generally prohibits the enforcement of non-disclosure and non-disparagement provisions in pre-dispute agreements specific to sexual harassment. So one of the areas of differentiation on a state-by-state level is what is the degree of conduct that's covered by the exclusion. At one end, the maximalist end, you have California, which is anything related to unlawful activity in the workplace. And then you have on the narrower side, for example, a settlement agreement that's specifically limited in terms of the confidentiality limitation to sexual harassment allegations. Can you go to the next slide, please? There have been some other efforts at the federal level to impose more onerous limitations. The Accountability for Workplace Misconduct Act was introduced into the last Congress. It, rather than the Speak Out Act, contained more expansive restrictions on confidentiality to cover claims of discrimination, harassment, and retaliation. There were additional process-based requirements for receiving and investigating complaints related to EEO considerations. That ended up dying in committee without action. However, it seems like it could be a contender to be reintroduced, and I think what we've been seeing at the state level is the state will pass by enacting some sort of restriction that was specific to settling sexual harassment allegations. And then there would be kind of scope creep over time, such that the restrictions would include just any general unlawful activity in the workplace. Next slide, please. So I'll close out the first part of this presentation with recent activity by the Securities and Exchange Commission, which I think really provides a preview of what we're going to see next in terms of both the state, administrative, and federal focus on confidentiality provisions. In 2010, the SEC promulgated Reg 21F17, which prohibits impeding an individual from communicating directly with the SEC about a possible securities law violation, including enforcing or threatening to enforce a confidentiality agreement. Now, this regulation doesn't create a private right of action. An individual cannot go out and file a lawsuit against the company based on the theory that there is some overbroad agreement that runs afoul of this regulation. Only the SEC can take action to enforce it. And frankly, your odds of being unlucky enough to be selected for an investigation on this provision are pretty low. There have only been a handful of enforcement actions, approximately 24, I believe, since 2014, but it's certainly something you want to avoid if you can. The SEC's enforcement actions, when they have opened an investigation into a company for potentially violating this provision, have included some pretty extensive equitable relief. Oftentimes, the company will go and need to affirmatively notify the entire population subset of employees who, and including former employees, who have an agreement that allegedly violates 21F17. They have to distribute some kind of notification that says that they will not enforce the agreement. And then they have to pay a statutory penalty of some amount of money, usually in the hundreds of thousands of dollars. In more recent press releases, the SEC has specifically noted that its past enforcement activity should be a guide to employers and to exchange-regulated companies to be cognizant of their obligations under this provision and sort of signal that they expect to have both more enforcement action in the future and that the fines associated with enforcement actions for an alleged violation are going to be more significant than the already pretty significant numbers that you see here. One thing that I would note, too, is that the SEC's position on 21F17 has not actually gone to the mat in an ALJ proceeding or a court proceeding. All of these have been settlements. And so it's still a little bit murky to tell where exactly the line is in terms of what a company ought to do in order to comply with this regulation. The SEC has taken the position that it should be specifically named as part of a carve-out from the confidentiality provision rather than just a simple, generic carve-out for reports to administrative agencies, for instance. Probably the most notable thing about what the SEC has done here, though, is if you look at the language here, it says in the rule that the prohibition is on any person taking action to prevent an individual from contacting the SEC directly, right? So all of the other examples that we've gone through have related to a provision in an agreement or a provision in a contract between an employer and an employee. But the exchange rule is actually broader than that, right? Is it would reach things like policies or handbooks, something that I'm sure Sewell and Carrie are going to talk about when it comes to the NLRB's perspective on those things. But, you know, the SEC fundamentally has the same perspective, right? It's a very whistleblower dependent organization for some of its largest investigations. And it does not want to have an argument for the employer to have an argument, to have a concern that an employee is chilled from reaching out to the organization. And so not only has there been scrutiny for the actual confidentiality agreement or some kind of confidentiality provision contained in the contract, but the SEC has also begun looking at the policies that the employer puts into place and whether there's an argument that those policies could be used in order to suppress whistleblower activity, either intentional or inadvertent. The final thing that's worth noting with respect to the SEC's investigations and settlements on this front is that, to my knowledge at least, based on my investigation, I don't believe that any one of these settlements under 21F17 was incidental to another dispute proceeding, right? So it's not that the SEC was conducting an investigation into an alleged violation of some other securities rule and then just happened to come across a non-compliant agreement. Rather, there was some kind of tip to the agency, they had a copy of the agreement, they investigated it, and then ultimately decided to assess penalties on that basis. So that's worth noting too. It's not something where if you're all clear on the securities front generally, that this isn't a concern for you. The SEC has indicated that it does have interest in just enforcing this rule on its own terms. Next slide. So with that, I'll turn it over to Carrie and Sewell.
Thank you, Alex. I'll start the discussion on the topic of NLRB trends and severance agreements. And specifically, we'll discuss the board's view on the confidentiality and non-disparagement provision in a severance agreement, as well as the GC's view on non-compete agreements. And let's first talk about McLaren-McComb decision, the famous, or some call it infamous, decision that was issued by the board in February of 2023. McLaren-McComb is a hospital in Michigan that employed about 2,300 employees. And at the beginning of the COVID-19 pandemic, this hospital decided to temporarily furlough 11 employees. And they were greeters at the surgery center, and they believed that they were non-essential employees. And about 3 months later, they decided, okay, let's go ahead and permanently furlough them and then offer them a severance agreement. All 11 employees signed the agreement, and the severance agreement was pretty ordinary. Employees received a severance pay in return for a release and a few other conditions, such as a confidentiality provision and also a non-disparagement provision. What you guys are seeing on this slide is the actual language of the severance agreement. And the confidentiality provision basically says the employee agrees that the terms of the agreement is confidential and he or she will not disclose it to anyone except for a spouse, legal advisor, and a tax advisor, or unless legally compelled to do so, which is pretty common. The non-disparagement language is actually at the second sentence of this provision. This provision was termed a non-disclosure provision. And under the non-disparagement provision, employees are prohibited from making any statements prohibited from making a disparagement statements about the employer, their parents, affiliated entities, officers, directors, and etc. To other employees or the general public, which is a very common language. Next slide, please. And a charge was filed and a complaint was issued where the complaint alleged that the confidentiality and non-disparagement provisions violated the Section 8A1 because they were too overly broad and they tend to interfere with, restrain, or coerce employees' exercise of Section 7 rights. The ALJ, which is the district court equivalent of a district court judge, looked at this first and held that those two provisions were actually lawful under the then current Baylor and IGT standards. And under that standard, the ALJ held that they were lawful because they were voluntary in its nature, and also because the prohibition only applied to post-employment activities, and also it had no impact on employees' receipt of any accrued benefits. However, the board in the McLaren-McComb decision held that no, those provisions are unlawful because they tend to interfere with, restrain, or coerce employees' exercise of Section 7 rights, and a mere proffer of a severance agreement that included those two provisions are unlawful. And what you guys are seeing on this slide is the board's reasoning for why the non-disparagement and the confidentiality provisions are unlawful. And if I were to summarize it, in essence, what the board was saying is employees have a Section 7 rights, and in their rights, they have the right to discuss the terms and conditions of employment, and also discuss those terms and conditions of employment to improve them. And to that end, they must be permitted to discuss those terms to anyone, not just limited to their spouse, legal advisors, or tax advisors. They should be permitted to discuss them to the media, the government agencies, and other employees, former or current employees, as long as the communication is not so disloyal, maliciously untrue, or reckless. So non-disparagement provision that prohibited employees from disparaging employers, which includes employers' workplace, and also confidentiality provision that prohibited employees from discussing the terms of the severance agreement, are unlawful because they're prohibiting employees from discussing those terms and conditions of employment. Next slide, please. So under McLaren-McComb, the new standard is this. First, they overruled the Baylor and IGT standard, and they return to the pre-Baylor and IGT standard. And the new standard is a severance agreement is unlawful if its terms have a reasonable tendency to interfere with, restrain, or coerce employees in the exercise of their Section 7 rights, and that employers' proffer of such agreements to employees is unlawful. So if you look at a standard, a Baylor and IGT standard, the board under that standard, they looked at the circumstances surrounding the proffer of the severance agreement. And also they held that mere proffer of a severance agreement is not unlawful activity in and of itself. But under now McLaren-McComb, the board is saying that if the provisions have a reasonable tendency to interfere with employees' Section 7 rights, they are overly broad and unlawful, and mere proffer of a severance agreement, including those provisions in and of itself, is unlawful. Next slide. So this decision was not received well from the employers community. Labor lawyers like Carrie and I, we always tell our clients the National Labor Relations Act applies to unionized employers and also non-unionized employers. However, some employers still don't think this is a thing that they need to follow. But after the McLaren-McComb decision, we received a lot of questions from employers that we normally do not even hear from, because they wanted to know, what does this decision mean for my company? What about all of my severance agreements that I have? What about the confidentiality agreements that I have? And about a month after the McLaren-McComb decision was issued, the GC Abruzzo issued this memo, 2305. It's about a 7-page memo where she offered responses to some common questions that I assume she received from the public. So let me just highlight some of the questions that we commonly received. First, are severance agreements now banned as a result of the McLaren-McComb decision? No. The answer is no, and the severance agreement is still enforceable as long as the severance agreement includes provisions that are not overly broad and unlawful, and that does not restrict employees' Section 7 rights. The second, what if an employee does not sign the severance agreement? Again, it doesn't matter. Under McLaren-McComb, mere proffer of the severance agreement that includes unlawful provisions in and of itself is unlawful. Third, does this have a retroactive effect such that it may invalidate agreements entered into prior to February 21st, 2023? Or would a violation only be considered if an employer attempts to enforce a previously entered into agreement? This decision does have a retroactive effect. And also, it's important to note that the NLRB has a 6 months of statute of limitation. But in the memo, the GC did signal that if she receives a charge in the future that alleges claims of unlawful provisions in a severance agreement, but those agreement is barred, it should be barred by the statute of limitation, she may pursue an argument that they are not time barred and may continue to pursue that argument. And also, just because you don't enforce it, it doesn't mean that you are completely, free from this decision. The GC is saying that and the board is saying the maintenance and also enforcement in and of itself is unlawful. It's important to highlight that the GC here signal that the employer should consider contacting employees that certain overly broad or unlawful provisions are no longer in enforcement due to this decision. But again, that's the GC's position. Next question, would the entire severance agreement be null and void if there is just one overly broad provision? No. The board and the GC's position is generally just only the overly broad provisions will be voided and not the severance agreement, regardless of whether you have a severance clause. And here, GC also, again, repeated her suggestion that employers should proactively contact the employees who may have this unlawful provisions, severance agreements with these unlawful provisions. But again, that's the GC's position. Next slide. Are there ever confidentiality provisions in a severance agreement that could be found lawful? Yes, even the GC says that if they are narrowly tailored to limit the dissemination of a proprietary and trade secret information for a period of time based on a legitimate business justification, then such provision is lawful. As to the confidentiality of the severance agreement, GC noted in this memo that financial terms, limiting the disclosure of financial terms is lawful, and I agree with that. But I guess that the key will be what is considered financial terms, right? I have clients who said, okay, then I just want to limit the severance pay amount. I have some clients that say, well, I want to expand the definition of financial terms to include severance pay, maybe the extension of health benefits, or some compensation for unused sick days or vacation days. So I think it really depends on how you define financial terms and in your comfort in terms of the risk here. Second question, are there ever non-disparagement provisions in a severance agreement that could be found lawful? And GC here said yes, as long as they are narrowly tailored to limit an employee's statement about the employer, not the employer and the related entities and the officers and the directors and et cetera. Narrowly tailored to limit an employee's statement about the employer that is maliciously untrue. So I also tell my clients that yes, if you want to put a narrowly tailored non-disparagement provision in your agreement, let's try to tailor it where you restrict a disloyal or malicious untrue statements about the employer's products and services. Because I think I found that a lot more clients are comfortable with that language, and this for more conservative employers. Last question. Would a disclaimer save overly broad provision in a severance agreement? No. the GC has said that instead of putting in a disclaimer or savings clause, go ahead and narrowly tailor the provisions in the first place and put them in the agreement.
So could you, for everyone on the webinar, could you clarify what you mean by a disclaimer?
Sure. I think everybody is everybody's well aware of a disclaimer where the severance agreement include a sentence that says that none of this language in this agreement or this paragraph is included to prohibit your Section 7 rights under the National Labor Relations Act. Good question. Thank you, Alex. And also, I wanted to highlight another question that I didn't include in the slide, but that Carrie and I get a lot from our clients. Remember, this National Labor Relations Act protects employees. Employees meaning anyone who are not supervisors. So we've gotten a lot of questions from the clients where they ask, what's the impact of decision on severance agreements offered to supervisors? And what we're telling our clients is that supervisors are not protected by the act, meaning the board does not have any jurisdiction to review severance agreements that are offered to supervisors and say whether any of those provisions are lawful or not, with very limited exceptions. And the GC agrees. GC states that although generally the board does not have jurisdiction over supervisors, and the severance agreements offered to them, if the supervisors receive severance agreements after they were discharged unlawfully, then they may try to push the jurisdiction protection over supervisors. So simply put, when are supervisor discharge considered unlawful under the act? When they are interfering with employees' right to Section 7 rights. Examples: if supervisor is terminated and offered a severance agreement because a supervisor refused to engage in unfair labor practice. If a supervisor is terminated and then he or she receives a severance agreement after testifying against employer's interest in a ULP hearing. In those very limited situations, the board will attempt to extend the protection, but generally it's important for the employers to remember that the act only covers non-supervisory employees, and that we always recommend that you have a different set of severance agreements for supervisors and non-supervisors. And also this memo, the 2305, ended with GC's comment that in addition to the confidentiality and non-disparagement provisions, she believes some provisions such as non-compete provisions or non-solicitation provisions or agreements may be considered unlawful under the act. And Carrie will expound on that more.
Great, thanks, Sewell. That's exactly right. So I think when GC Memo 2308 landed at the end of May, I took the view that my parents often took when I would misbehave as a child. They were, and I was, disappointed but not surprised. 2305 signaled that this was happening, and then we got 2308, wherein General Counsel Abruzzo informs the regions of her view of non-competes and that they violate the National Labor Relations Act for a purported host of reasons. And the block language is quoted there, except in limited circumstances, I, Jennifer Abruzzo, believe the proffer, maintenance, and enforcement of such agreements would violate Section 8A1 of the Act for a few reasons, beginning with these non-compete clauses purportedly would tend to chill employees in the exercise of their Section 7 rights. Now, before I get into this further, I think even these three primary bullets that we've laid out are pretty darn speculative. Take the first one, this notion that employees know, purportedly, that lost income will be difficult to replace if they are discharged for exercising their rights under the Act. The practical reality that we see in non-competition world, and as Alex can expound upon later, is that most non-competes that hold up are pretty narrowly tailored to a specific industry or group of companies. or a geographic location. So this notion that non-competes proffered to employees will prohibit them or inhibit their ability to move to a new employer, I think is really speculative at best. Similarly, this second bullet, I think, quite frankly, is just unsupported under current board law. This notion that bargaining power is undermined in the context of lockouts, strikes, and other labor disputes is really not accurate. Current board law holds that non-competition agreements in the context of collective bargaining agreements or negotiation thereof, are mandatory subjects of bargaining. Now, to me, that would logically follow that collectively, these employees can waive their ability to leave their job, or in other words, they can collectively decide to enter into a non-competition agreement. And that's typical give and take in the context of collective bargaining negotiations. Employees sometimes give things away in order to get something else. And this third bullet is similar as well. Former employees are unlikely to work together at a local competitor's workplace, limiting their ability to leverage prior relationships to encourage exercising their rights. So I think this has the most assumptions out of any of them. This notion that folks are all going to collectively leave together or begin to leave together and then start calling out their friends in order to work at a local competitor's workplace, with the idea behind that being the people left behind at employer one, still working there, will then be able to advocate for wages, hours, and terms and conditions of employment that are better than what they had before this other group of folks left. Now, I'm going to get into the specifics of the memo in a minute here, but I also want us to think through logically and as a matter of practical reality, how this would all purportedly work. And so from a pure nuts and bolts perspective, we've not seen, apart from one complaint that issued under this general theory that non-compete provisions under the NLRB are invalid, and that matter unfortunately settled. And so we don't have a lot of good data or information on what an ALJ, an administrative law judge in the first instance, or the National Labor Relations Board reviewing that ALJ decision would ultimately do. But that's exactly how that will have to work out in practice. The regions, after considering the charge that comes in as a complaint, will look to file a charge. To the extent that that's not settled, it will be tried before an ALJ who will make a decision, and then thereafter that will go to a board, and then ultimately the reviewing court. And, in certain instances, perhaps the NLRB might seek an injunction under Section 10J of the Act. Now, I think that is sort of a critical aspect of this and demonstrates really, in my mind at least, and I think in a lot of our clients' minds, the folly of this idea that the NLRB is equipped in any way to litigate non-compete cases. And just as for some context, current trends are such that as of the end of February, when the GC put out a memo about this, it takes about 9 months for the region's Section 10J office to issue an injunction or to seek an injunction. Now, at that point, and as we all know, and as Alice can better explain to all of us, non-compete litigation burns absolutely white hot. When somebody leaves, it is important to be able to go to stop them, if necessary, as soon as possible in order to protect your legitimate business interests, your confidential information, your trade secrets, your customer lists, your pricing lists, and a whole slew of other things. This notion that even under an injunction proceeding, the NLRB would take 9 months to get around to seeking an injunction, at that point, all of the damage is done and has been done for a significant period of time. And beyond that, and commendably, the NLRB did recently appoint 6 additional administrative law judges within the past week to help to alleviate the significant backlog that they have in case processing. The notion that the NLRB would be able to move these throughout the regular course is just unlikely as well. Not to pick on the regions, because they are doing their absolute best with a flood of unfair labor practice charges. But a typical case I've found from charge to request for information is now taking in the area of at least 3 months. And then once a position statement is submitted on behalf of the employer or the charged party, you've got another couple months at a minimum until that charge is withdrawn, or the region reaches out and says, hey, absent settlement, we're going to issue a complaint. So with all of these delays, this basic structural reality of the NLRB entering into the non-compete space, even only with respect to non-supervisory employees, really just doesn't make a lot of sense. So let's move on to the next slide, please, and we'll talk about when and how the General Counsel thinks that these non-compete provisions would be overbroad. And this in itself is really quite very broad. This blocked language I think is worth just reading out. These non-compete provisions are overbroad when they could reasonably be construed by employees to deny them the ability to quit or change jobs by cutting off their access to other employment opportunities that they are qualified for based on their experience, aptitude, and preference as to type and location of work. So, I mean, ultimately, with very limited exceptions that we'll talk about as we get further along here, the General Counsel really is taking the position that any non-competition agreement that would prohibit an employee from seeking a job that they want in the area that they would like to work for any length of time appears to be completely unlawful. Now, before I continue, I think it is worth noting, as Sewell mentioned before with respect to 2305, a lot of what's in there remains aspirational. This is guidance. What the General Counsel has said to the regions is not law. It's what she believes her view of the law is, or should be, excuse me, but she herself concedes that this is not the current state of the law. And as I said before, all of this will have to wend its way through the board's proceedings, and then a court of appeals, either the DC Circuit or any circuit in which the employer does business. And in my mind, without question, this, to the extent it remains as an idea, would ultimately get litigated before the Supreme Court. So we won't have answers on any of this for quite some time, but it significantly changes the risk calculus for employers, as I'll get into in a minute. But before we do that, let's go back to these ideas that the General Counsel has about how non-competes will impinge an employee in exercising their Section 7 rights. So the first one, at least to me, I can follow the logic, even though I'm not sure that it's totally correct. A non-competition agreement, according to the General Counsel, would prohibit an employee from, or a group of employees, excuse me, from concertedly threatening to resign to demand better working conditions. Now, that's ultimately not true, but threatening to resign and tying that to better wages as an example, say, if you don't pay me $2 more an hour, I'm going to walk out the door, would unquestionably be protected concerted activity under extant board law. That's not a question. And so I think what the General Counsel is doing here is grafting on this idea that because an employee would be able to move on to a smaller range of potential next set of employers, this impinges upon their rights to seek a job. Now, it doesn't impinge upon the right to seek any job, just a limited class of jobs. And that doesn't account for the fact that, as we know, and as Alex could say in his experience with this, lots of non-competition agreements as drafted are just overbroad on their face or unenforceable for a variety of reasons. And I don't think that this reasoning from the General Counsel takes that into account. But in any event, it is not prohibiting folks from getting any job, just a specific subclass. So the second one I think is interesting too, in that the General Counsel acknowledges that she is going out over troubled waters here, and that this is not based in extant board law. So this notion is that non-competition agreements would prohibit employees from carrying out concerted threats to resign or otherwise concertedly resigning to secure improved working conditions. So in other words, this General Counsel is saying, because you have this non-competition agreement, the idea that you will wave your fist and walk out together with your brothers and sisters in employment is really a futile or limp effort because you can't go get another job. And that's really the same, the response to that is the same as the response to number one. there's certainly a slew of jobs available. It's just you can't go get the exact job that you want. And there are likely, in many circumstances, good reasons for that. As Alex said at the beginning, what employers are trying to do with non-competition agreements in many instances is protecting key employees walking out with the keys to the store, or the pricing list, or the customer list, or the way to make the newest widget that they were working on at company A and moving on to company B to go finish. Now, number 3 is sort of a follow-on to number 2 in that.
Hey, Gary,
sorry, were you saying something?
One quick question on this. It was just interesting. So we've been talking entirely in the non-compete context. Has the GC said anything about employee non-solicitation provisions? Because that's one thing that is interesting, right? Is there's this whole other class of covenants, employee non-solicit. It seems to fall directly in this, and I don't think anything that the board has put out even references those covenants, which obviously involve that interest in a much more direct way.
Well, so that's a great question, and 2308 sort of tips its cap to that in saying that one of the ways that non-competition agreements would impinge on Section 7 rights is an employee would be prohibited from or have issues with going to a new workplace and then soliciting their colleagues to go work for such a competitor as part of a broader course of protected concerted activity. Again, though, this is one to me that doesn't make a lot of sense. Because if you think about it, ultimately, when somebody leaves employment to go to work for a new employer, I don't know, and I don't really understand how they can engage in protected concerted activity on behalf of old employer. Former employees and non-employees have different rights and responsibilities under the Act as compared to current employees. So, this notion that you can't leave and you would be prohibited from soliciting employees, I'm not sure that it really impinges on employees' rights under the National Labor Relations Act. And so let's move on to the next slide, please. So now what I think is interesting and what the million-dollar question is what are the exceptions? And unfortunately, the answer is we don't really know. The exceptions must be, according to the General Counsel, very narrowly tailored to address special circumstances justifying the infringement on employee rights. So I think the employer community at least is hoping that these exceptions would be crafted around things like protecting trade secret information or confidential information, or ensuring, as I was talking about before, that an employee that's working on a new widget doesn't just walk out the door with all that information they have and start to work on a new widget. Now, in some respects, 2308 does tip its cap to the notion that employers are still able to protect their trade secret information, but I will say we're not sure how narrow even that notion would be construed. And I think more troublingly for the business community is what is not protected or what is not a legitimate business interest according to the General Counsel, which is to avoid competition from a former employee. Now, under restrictive covenants law, and Alex, if I just completely butcher this, please feel free to jump in. The basic gist is that you are free to compete, but you're not free to compete unfairly. And that's really what a good restrictive covenant agreement will do. But I think what Jennifer Abruzzo is saying is that's not going to be good enough in my view, and in order to maintain protections for employees under the National Labor Relations Act. And similarly, this notion that it's no longer a legitimate business interest to protect the business interest in retaining employees or a special investment in their training. And, in my experience, a good non-compete agreement will reference that sort of in the beginning for good and valuable consideration, along with the investment that we've placed in our employee ABC restrictions go into play. And the General Counsel is basically saying that that's not the case anymore.
And a number of state statutes have expressly identified protecting the interest in developing an employee and the investment associated with that as a legitimate business interest that's sufficient to substantiate a restrictive covenant.
Right, exactly. So I think at this point, let's move on to talking about, what should employers be doing? What should we be doing in order to mitigate risk and to think about how to comply with these edicts from various government agencies? So let's go on to the next slide, please. So, I think, Alex, go ahead and answer this.
I was going to say I've got the first bullet point here, so sorry for jumping in. The first thing is, there again has been a lot of activity where you're seeing a shift in terms of the scope of these restrictions. Now, it sounds easy enough when you talk about a confidentiality restriction that prohibits, for example, the disclosure of an alleged sexual harassment investigation or something like that. But as we see this move to a more general prohibition on confidentiality restrictions for unlawful activity at work or activity believed to be unlawful, I think that you really ought to take a look at your confidentiality agreement in terms of how you're defining confidential information, right? Because if, for example, you have that California language, you're going to have to be very particular in order to ensure that it's covering the kinds of things that you want to have covered. Moreover, one area that still hasn't quite yet been explored, but I think we're going to see a ton of activity on is return of property provisions, right? So everything that we've been talking about has really been in the form of communications or disclosures, right? And I think there's a pretty fair number of the more aggressive agencies and states that have taken the position that as part of your ability to disclose information, you have the ability to retain the related documents. There are certain states, New Jersey and Massachusetts come to mind immediately, that have a common law authorization for the employee to retain documents related to certain categories of employment claims. Now, I mean, that causes me a lot of heartburn, right? When you start to expand that to just any unlawful activity. So I think that employers are going to have to be a little bit more careful when you have that standard kind of employee departure, maybe you've got some forwarded information. I think you're going to have to take a little bit more nuance. Well, not only did they take stuff, but like what circumstances do we have to suggest that it was being used in an improper way? And the analysis is going to shift a lot more from just the mere possession of information into the actual use or disclosure of that information to impermissible parties or to unfairly compete against the company. The other big issue that I think employers should really keep an eye on is what is the impact of an overbroad provision on the agreement's enforceability. So Sewell mentioned that an overbroad restriction on confidentiality, for example, would not void the entire settlement agreement. But does that void the entire confidentiality provision? That's an open question in a lot of those recent state laws that have been passed. And it's unclear if we're following kind of a rule against perpetuity sort of regime where if I can be creative and imagine a scenario where this agreement could be read in a way to potentially infringe on some scenario where somebody might be engaging in protected activity or some unlawful conduct could be covered. Does that mean that I have successfully invalidated that agreement for any potential purpose? That's a really open issue right now, both under state law and under federal law. And I think that we really ought to take a close look at that. Finally, with these increasing state-specific confidentiality restrictions, it can become a little bit more cumbersome to draft an all-inclusive agreement that contains all of these restrictions. And so I think that as you're going through these, take a close look if you have a multi-state agreement and ensure that you're getting a language that really captures the nuances of these various provisions across the different state-specific application provisions that you might have. Sewell or Carrie, anything else to add to that for things to keep in mind?
I guess I'll just emphasize that, again, while the decision applies retroactively to employers, it's really important for employers to sit down and think about what severance agreements do I have, what confidentiality agreements do I have for supervisors and for non-supervisors. And for non-supervisors, those employees who are protected under the National Labor Relations Act, I think it's important for the employers to review their current agreements and do a risk analysis. I have a lot of clients who say, okay, give me the most conservative language. Okay, then what? And then a little bit more. And then so they can decide as to, okay, what are they comfortable with and they'll have to review this with their legal folks, but also the business folks. And also another thing for them to think about is what kind of employees are getting the trade secret and proprietary information, right? I think a lot of employers like to think that all employers have access to proprietary and trade secret information. And because of that, they want to have a very broad confidentiality agreement, and also they want all employees to sign that. But let's think about that. Who's really getting proprietary trade secret information? And last but not least, I know of a lot of clients that sometimes like to have a broad non-compete provisions or non-compete agreements. And most of the time they won't enforce it. They say they normally don't enforce it, but they want to use it and maintain that as a scare tactic. But I think given the GC's position that maintaining a unlawful non-compete provisions or non-compete agreements could be a violation of the act, I think employers should think about the risk that's associated with maintaining a non-compete agreement that even if you believe it's overly broad or you're not going to enforce it. Carrie, anything else?
Yeah.
Well, just to jump off Sewell's point real quick, the other component to potential liability is not only to the board, but also under state law. There are increasingly a large number of states where you can have some kind of penalty, including fee shifting, if you have an overbroad agreement. And so you could potentially run into problems with a private litigant suing you for a declaratory judgment to either invalidate their own agreement or some class of individuals. Sorry, Carrie, go ahead.
No, that's all right, and I'm glad that you jumped in. I actually saw a question in the Q&A that I think is worth going over here. We've been talking a lot about the difference between supervisors and non-supervisors under the NLRA and splitting up sort of your template agreement to the extent that you have one. So, I mean, just to define that, a supervisor under the National Labor Relations Act, as a general proposition, will have the authority to hire, fire, direct employees in the course of their work, have some level of managerial control, or at the very least, they will report or make recommendations to somebody above them, and those recommendations will be given particular or at least significant weight, even if they don't have the final say. And so that can get sticky sometimes as to who's a supervisor under the NLRA and who's not. And I want to say too, just before moving on, that that definition, of course, will be different under every different statute. So it'll be different in kind to the definition of supervisor versus non-supervisor under the FLSA is one example. And so that's really something to watch out for too when you're crafting these agreements. Who really is a supervisor, and can we defend that position if we have to? So I think at this point, let's just move on to the last slide, which is some additional strategies for compliance and risk mitigation here. And I think, the very first one is what Sewell touched on. And I think that that's critical. And that's a lot of what we've been doing, is having conversations with our clients about what agreements make business sense, if any. Is this something that's worth rolling out to your employees? Do they really have the keys to the store? Do they have information that you all really need to be protecting? And to the extent that they don't, and you're not going to enforce these, perhaps it's time to revisit the general non-competition framework that you've been laying out. Sewell or Alex, what other thoughts do you all have on compliance and risk mitigation?
Well, before we do that, I've gotten a bunch of questions about the CLE code. No, you didn't miss it. We were just about ready to get there, but I see it pouring in, so I want to make sure we get that before time expires in case somebody has a 4 o'clock call. So the CLE code for today's program is SS Seyfarth Shaw 2487. That's SS 2487.
Got it. And likewise, we will be sharing the slides, I think, thereafter. We'll be emailing those out. And then one last piece, given it's 3:59, and I don't want to miss this, is we owe special thanks to our summer associate, Samantha Franco. She is a student at Emory Law School, and she helped us immeasurably in preparing all of this. So before we wrapped, I just wanted to tip my cap to her as well.
Great. Any other questions before we head out? All right. Hearing none, I think we'll give everybody a minute of their life back. Thank you so much for attending.
Thank you.